wanted to welcome you here. This is a facility that is a beautiful facility. We definitely want to thank them for loaning us this facility this evening at no cost. And we are extremely grateful for the continued support of our partners. We have a lot to cover this evening, and we know you guys have a lot of questions that you want answered. So in the essence of sparing time, I wanted to take just one moment and introduce a couple of my colleagues that are here tonight. Commissioner Darrell Glenn, who this is his district, is going to come up in just a few minutes and welcome you as well. We also have Commissioner Sally Clark in the back. She went through this last year at Paso Canyon. So my name is Peggy Littleton, a Paso County Commissioner, and our Commissioner Glenn wisely in the beginning said, okay, we're going to divide and conquer so that no one person who's a commissioner is overwhelmed. And so he divided us up into different groups and areas, and one of the areas that he allowed me to cover and to begin to kind of take a lead in is insurance. And I know from talking to many friends of mine who are Black Forest residents and Waldo County residents, that there right now at this point in time for many people are more questions than there are answers with insurance. And so what El Paso County is doing is really facilitating and being the disseminator of messages and meetings. Which ones can you attend? Where are they? What time are they being held? Because I know you guys just want to really collect as much information as you can now so that you can all make very well-informed decisions. And we are certainly the facilitators for helping you get that information. I want to thank you. I'm going to be around for the whole meeting. If you need to come talk to me afterwards, I would love to hear from you. We also have several different committees that I'd love. If you'd love to head the insurance committee and be on my sounding board, I want to know that from you. If you don't feel comfortable with that, but you're really interested in helping out with what does animal control look like in the future, I'd like to hear that from you. If you would like to be some of the families that help facilitate the mentoring, what we call Mentors Connections, between Waldo Canyon and Black Forest families, that's also an area in which I am in charge. So let me know if you want to participate in any capacity in that area, and I will be happy to have you come work with me together in that capacity. So let's have Commissioner Glenn come up, just welcome you so we can stay on time tonight. Commissioner Glenn.
Thank you very much. And Peggy's great to work with. I just want to briefly just give you a date to put on your calendar, and that is August 22nd. And that is going to be the first of 3 town halls that we're going to have. Commissioner Littleton is going to help co-chair that with me. But we're going to dedicate that meeting to lessons learned. We want to hear from you as far as what's going on, get your feedback. We're going to spend 2 hours allowing you to talk to us about what are the things that went right, what went wrong, and what are the things that need to change. We're going to have 3 different sessions spread out throughout the year, but our goal is to create a lessons learned document that we can build on. You know, unfortunately, we're becoming national experts in this area, but I think it's very important for us to really diagnose everything that's happening here, capture those lessons learned. There are good things that happen as far as great stories that need to be told, but there are also things that we need to make sure that we improve on in the future. But I want to make sure that I hear from you, so this is an opportunity. August 22nd, it's going to be from 5:30 to 7:30. It's going to be at the 10th at New Life. So please put that on your calendar. We're going to try to make sure that we promote that, and we want to make sure that you have an opportunity to participate. So Karen, I want to keep you on track. I want to thank you very much for inviting us and hosting this event for us, and turn it over to you.
Hi, welcome. I just want to let you know that Karen Chair is here. You probably saw the truck in the parking lot. Again, the community has generously donated so much. They just want to make your life a little easier and lighter. Please be sure to honor the gifts and the time that people from Karen Chair have spent being here, and stop by on your way out with your car, and they have some things for you. So thank you for being here again. Hopefully we'll have more in this series of Roadmap to Recovery workshops that will be timely, and you'll get much help here. Thank you. Thanks, Karen.
Good evening, everybody. My name is Karen Lemus, and I'm the Disaster Recovery Aid Outreach and Education Study for United Policyholders, a nonprofit organization. history, which was the Cedar Fire. It was a devastating experience. It's been almost 10 years, and looking around at all of you, I recognize what I see in your faces right now. I've been there. It's a very disorienting, devastating experience. UP, United Policyholders, the nonprofit charity, was really helpful. I found them when I was online trying to find some insurance information and recovery information navigating my own loss. They were so helpful to me in my own recovery that after I got back to my rebuilt home in 2005, I started volunteering for the organization. This is now my 7th disaster, coming in for UP and just facilitating these fire recovery, insurance recovery information meetings, so I hope they're useful. We're kind of, don't have a clicker, so I'm going to be manually moving forward, so I'm going to kind of be awkwardly here by the computer, but we're going to make it work. About UP, United Policyholders is a non-profit 501c3 charity. Our goal is to educate consumers about their insurance rights and try to level the playing field. We're funded by donations and grants, and the overwhelming majority of our work gets done by volunteers like myself. People who who recover from natural disaster now want to pay it forward, and also very consumer-friendly professionals who are very grateful to have their information. They often donate their information, their expertise, and their time. We're grateful for that. Our website, www.uphealth.org. Our experience in disaster insurance claims work stretches back well over 20 years now. This is just a list of, the disasters our organization's been involved in recovery with. Most recently, again, working in the Walden County community, partnering with Commissioner Clark back there. We did some recovery work, roadmap to recovery for that community. Hyde Park up in Fort Collins. 4 Mile Canyon Fire just 3 years ago. So we've been in Colorado multiple times, unfortunately, in recent years. All the information that we give in these presentations is for general information purposes only, until like our lawyers, of which I'm one, drafted this up. But all of our speakers are volunteering their time. We thank them for that. In terms of, we'll have our informational educational program tonight, but there are also a number of other free educational resources and recovery tools from United Policyholders. We're here to go through them. The very first one, and very importantly, is our website. Open 24/7, www.uphealth.org. You may not have the time to look at it tonight, tomorrow, next week, or even in 2 weeks. But as the dust continues to settle and the boat slowly starts to right itself in your recovery, and you need information on insurance recovery, tip sheets, template forms, samples, a whole Q&A form, this is a great place to turn, all right? Our Ask an Expert form. A lot of times something will come up, maybe you get correspondence from your insurance company or a conversation with your adjuster, and you're like, I'm not quite sure. What did that mean? I don't really understand everything. We have great resources on the web, but if you have a specific question, you can register online for free at Ask an Expert, where you can literally go in there and ask a question 24/7, and it is directed to an expert in the field. You can choose who you direct your question to. An attorney, a claims handling professional, a previous catastrophic loss survivor like myself. Nobody sees your name or contact information, but when those people answer, you see theirs. So that way, if you have any follow-up questions, you have that information, but your privacy and your identity is protected. So it's a really great information resource to have already. Useful tools. Our little yellow book, which my understanding is many of you, if not most of you, received this at the Disaster Recovery Center. If you did, then I've actually already met some of you as I read the first chapter of that book. So I've already conversed a little bit with some of you in writing. We also have our flash drive, which is a personal property inventory flash drive to help you work on that portion of your claim. It's got a memory jogger sample of completed inventory, which is great when you're sitting there trying to remember every single thing that was in your house. There's a depreciation template. There's a sample form that you can use, again, very user-friendly. Also, our claims notebook, just to help you get organized. It's basically an organizer, just so you can take notes, it's got room in it for business card holders, just to help you stay organized as you try and navigate this process. If you haven't received any of these, we have them on the way out. If you run out, you just have to email info@uphealth.org and we'll get those out to you. All right, so all free disaster recovery resources from United Policyholders. Finally, and on the back of tonight's agenda, you will see our DSSN, our Disaster Survivors Support Network, which is our volunteer base of over 160 previous catastrophic loss survivors. Virtually all are total survivors, and virtually all of them lost their homes just like you in a wildfire. Nobody on that list can give you legal advice or professional advice. They are there because they've been through it and they've made it to the end. And they're there to provide an empathetic ear, a sounding board. You need to vent, and there's nobody to vent to. One of our volunteers is happy to let you vent and just, try to give you some encouragement. They've all walked in your shoes and made it to the end of the recovery. So again, they're happy to be there as just a useful resource for you and a listening ear and an empathetic ear for you. Again, our website, www.dphealth.org. All right, and I particularly want to say thank you right now to the County of El Paso for partnering with United Policyholders tonight. Again, Commissioner Sally Clark, Commissioner Darrell Lund, Commissioner Peggy Littleton, Brian Olson from the county staff, who arranged for us to get this venue, and it's such a great team over there. You just have such a wonderful group of elected officials just working so hard on your behalf. So we thank them. You Waldo Canyon Fire Survivors Volunteers. For better or for worse, you have a group in this neighborhood that came right before you. I'm really inspired by them. They are still recovering themselves. And yet they are still out here trying to pay forward and help you guys. And so I really tip my cap. I'd like to thank Carrie Olivier, who just got up and made our announcement. Steve, who spoke last time. Carl, for advice on me, also Rod. Just thank you so much again for being out here and supporting this community. So I really wanted to gratefully acknowledge them. All right, so our first of our three substantive topics. And as I get going on that, let me just tell you that we try to keep these fairly structured. We're going to go through our three speakers. We're going to move to Q&A. Thank you. Hold it, and then we're going to move to Q&A. So we're going to hold our questions, if that's okay with you guys, until our Q&A period so we can get to the substantive piece. And then, come heck or high water, we're going to make it to our breakout sessions, which is a key part of our model and roadmap to recovery. I know the questions went so long last time that we really didn't get to breakout sessions. But one of the key things that we found in the years that UP's been around, certainly in the 6 years I've been doing disaster recovery with UP, is candidly the most important resource that each of you have is each other. All right? Let me just tell you that from experience. Emotional support, leads on good contractors, who's doing what. You guys as a community of, Black Forest Fire survivors, trying to build that network amongst you guys together is really an important recovery strategy. So the breakout sessions really give us an opportunity for you guys to connect and get to know each other a little bit better. So we're going to make it there, come heck or high water by 8:15. So effective claims communication, one of the most important things that you can really try to get a good handle on early on in the claims process. It'll stand you in good stead the entire claim. All right, first piece of advice, an important one, keep a claim diary. What is a claim diary? Well, a claim diary is basically just a record of conversations that you have with insurance company personnel. You have a conversation with your adjuster, they say something about how long it's going to take to get you that first AOE check. I'm not talking about any sort of formalistic thing. Get a spiral notebook. That would be just fine. Keep an online just running log. But keep track. Who said what? Were specific promises made? Who said them? And what was the substance? And when was it said? This is a long process, and I know you've heard this before, but I'm going to reiterate it because it's true. This is a marathon, not a sprint. And sometimes let me just say this, it's not atypical to have multiple adjusters just because these claims are huge claims. They're large loss claims. So it's not atypical to have more than one, sometimes more than two, and even more than 3 adjusters. So it's important that you keep track of what was said, who said it, and when it was said. So if there's any disagreement about it later, you've got track. All right, so again, and it's one of those things I remember when somebody gave me this piece of advice at my disaster recovery center after my fire, I was like, all right. I mean, I don't know if I even know my name when I wake up this morning, let alone trying to keep a claim diary. What the person told me is what I'm going to tell you now. You do the best you can. All right, you're tired, you're exhausted, you're trying to hold down your job, recover from this fire. You do the best that you can at every step of the process. But to the extent that you can, do it. It'll be really helpful as you move through. All right, leading right off of this is creating a paper trail, a very important strategy in moving this claim forward. The better paper trail you create, the less likelihood of having any disagreements or problems. The more clear you can make things by creating a paper trail, typically the smoother the claim goes. So it's generally better to create this paper trail from the beginning to the extent that you can. Usually this creates a much smoother insurance claims process. Promises, representations, somebody says like, oh, hey, you don't have to worry about that personal property inventory, or somebody makes some other representation, or, hey, don't worry about that, there's no timeline for that. Confirm it in writing. Ideally, you would ask them to confirm it in writing, if the insurance company represented it. If they don't, or they're too busy, or they don't have the bandwidth, you confirm it in writing. A quick note, you can either send it by letter, and email is just fine. All right? So, email is very easy in this day and age. Dear Adjuster so-and-so, thank you for speaking with me today. I really appreciate you taking the time to discuss my claim. This will confirm our conversation wherein you stated, fill in the blank. All right? So you create a paper trail if they don't. All right? In writing is always better. So not only confirming representations, promises, or anything relating to the claim in writing, but if you have questions, particularly if you have policy questions or policy benefit questions, again, put it in writing, ask for a written response. Again, just the clearer you can make it, typically the more smoothly the process goes. Everybody knows what to expect, what's been agreed to, what's been said. Again, it leads to a smoother claims process. An important tip building on this is that any time that you send the insurance company a letter where you ask for anything, information, you ask them to do something, any time you're asking them to do anything, again, always put a written timeline for response. So if you're like, I had a question about my AOE benefits and one of the provisions of my policy, you lay out your question, you ask for response. Last line, thank you for responding within 2 weeks of the date of this letter. So commercially, reasonable time for them to respond to you. So if you're sending in a request for information, don't leave it open-ended, all right? Set a timeline, because that ensures that if you don't get a response, you can follow up. Oh, following up on my letter of August 15, 2013. Just wanted to say I haven't heard from you. Please respond. So again, don't give open-ended timelines for response. Ask for a response within a commercially reasonable time. So again, no open-ended questions. Be professional in your written communications. What I mean by that is, again, use proper grammar, punctuation, capitalization. You guys, nobody's at their best right now. Candidly, in my own experience, it really took weeks before my critical thinking fully, or as I might say right now, maybe semi-fully, came back online after that loss. If you're kind of like, okay, I wrote this letter, I think it's good, but I've had 2 hours of sleep last night, my boss is not as nearly as understanding now as he was 2 weeks ago, and I'm completely stressed out, ask a trusted friend to read over it. Or if you have a partner, team tag it. Somebody drafts it, somebody edits it. I'm saying that you want those communications to be professional in tone, all right? This is an important one, and it can really get hard, especially as the process goes on. Don't use your insurance company as an emotional outlet to vent your frustrations, either with the process or with the fire itself. As this process goes on, I hope all of your claims and your recovery goes smoothly. That would be best. But when large money, transactions are at stake, which these all are, particularly in the total losses and even in the partials, it's not uncommon for disputes to arise. When there's a lot of money at stake, it's not atypical for disputes to arise, whether it's something about excessive depreciation or the extent of your AOE benefits, or whether the scope of loss promulgated by the insurance company will fully remunerate you for your rebuild, things of that nature. Even if you're having frustration with the insurance company or you're still feeling angry about the fire, don't let that bleed over into your written communications. all right? And it's easy to have happen. There may be times for some of you where you're going to want to be like, you fill in the blank on that. It's not good. Don't. That's a bad plan. All right? So again, don't use your insurance company as an emotional outlet. Remain professional. And it's easy to let that happen sometimes. It's something you want to avoid. The tone of communication, if I could impart basically a tone that I would urge you to use, polite assertiveness. Polite assertiveness. All right? Nobody's going to walk over you. If you're dealing with your company in a polite, professional, and courteous fashion. All right? So remember that it's not personal, it's polite assertiveness. Hold on to that one out. That'll come in handy later as you move through. We would urge you to be the good guy in the transaction. You know, keep in mind that everything you write and you say is most likely recorded in the insurance company records. And you really want to avoid saying anything or doing anything that makes you appear to be uncooperative or the person causing delays. You're the good guy. Do you know what I'm saying? At every step, you're doing your best to move that claim forward to the best of your ability. And there might be reasons it's not going forward as quickly as you would like. All right, explain those. Be the good guy. All right? Insurance claim is a business transaction, and I just don't know how else I can put this. The adjuster may be friendly, but he or she is not your friend. I'm not saying that they're not a good professional or a good person. I'm just saying, let's not confuse these. They're not your friend. All right? For many of you, this will be one of the largest, if not the largest business transaction you will ever be involved in, because between the dwelling, your contents, your debris removal, your ALE, your other structures, when you start adding up all those different pots of money, this is a lot. So again, what you want to remember is that this is a business transaction, and you want to keep a business tone when communicating. The hard thing I found is it doesn't feel like a business transaction because it's your home. And so it doesn't have that feel that you would normally have when you're entering a large business transaction. Say it's when you purchased your home. You knew that was a business transaction, and the seller's agent wants to get as much for the seller, and your agent as the buyer wants to lower the price as much as they can. You understand that business transaction, that natural tension. It's the same dynamic. It's a business transaction, but it doesn't have that feel because the loss is so very personal. So just trying at every step to kind of step back and just say to yourself, it's a business transaction. It doesn't feel like that. Not here, I should say here. But I'm going to treat it like such, and that's how I'm going to proceed through this claim. That's going to help you move through it more effectively, more quickly. It's going to be the best way to go. Get educated so that you can effectively move through this claim. My experience has been is that the more claimants know, the better the process goes. The smoother the claims resolution process goes. The more educated claimants do better. They typically have less problems because they're laying a paper trail and they're confirming promises, and they're doing their best to keep everything as straight as they can given the challenges of the situation. But get educated. There's a steep learning curve in navigating a catastrophic loss claim. It's very different from maybe an auto or a theft claim somebody might have been through previously. It's as you have all well discovered now, it's actually multiple mini claims. You've got your structure, some of you probably have a different structural adjuster than your contents adjuster, potentially even a different adjuster from that than somebody who's adjusting your ALE and the other portions. Some of you might just have one, but it's not atypical to have it split into different adjusters. So again, coming to this meeting is a great step. So, when I was going through this back in 2003 and 2004, when I was really in the midst of my own recovery, I remember thinking, every time I went to one of these meetings, never knowing which ones were going to really be the good ones, where I got some good stuff, and which ones were a complete waste of time. If I even got one useful nugget of information, it was worth it. So I hope you get more than one tonight. But this is a great step, so good job. Resolving claims complaints, if you do end up having problems, which again, now looking forward, hopefully it'll go smoothly, but if you do end up with difficulties, just remember that documentation is everything, hence why the importance of laying that paper trail. so that if you have disagreement or problems, having like a paper trail will help. Again, effective claim plaintiffs don't use a threatening tone. Do you know what I'm saying? Again, professional, polite assertiveness, so that if you do have an issue or you are having a challenge, again, maintain a professional tone in that letter as you try to resolve that claims handling problem. Again, that letter should confirm how cooperative you have been and continue to be. All right, so laying out, you've been a good guy. Make sure, again, you ask for, if you do have a question or a problem, ask for a written response within a specified time frame. Be polite, be prompt, be persistent. Again, if you end up having a problem at some point, again, put that issue in writing, ask for a follow-up, in writing from the insurance company, follow up with a letter or with a telephone call. Did they get your letter? Do they need anything from you to respond? And, what can you expect a response? Go up the chain until the issue is resolved. Just because your adjuster says no, doesn't mean that the answer is necessarily no. You can, if you feel that the answer the adjuster gave you is not supported by your policy, go up and over, all right? So again, go up the chain within the insurance company. I had to do that multiple times on multiple parts of my claim. That is not atypical. Some of you will never have to do that. Some of you may, but just know that that's not atypical. The contract order is upward starting at the adjuster, all right? And then you're going to go up. Here we go, structure of the claims department, most typically. Adjuster, the supervisor, unit manager, assistant manager, claims manager, claims CP, regional claims CP, and then home office claims. Levels at the home office claims, again, hopefully you won't have to go that high up, but just to give you a general idea of how the insurance companies are structured, all right? Again, for more information, please visit our website. Before I turn over to our next speaker, I wanted to just hopefully, at the end of my little time here with you right now in this portion, give you some encouragement. And I put together just a few brief photos showing our own journey home in the hopes that it'll inspire you guys and give you that, it's going to be okay when you get there. All right, October 28, 2003, this is 2 days after our house burned. This is the first day we were allowed back into our neighborhood. That's my husband and I with the remains of our daughter's bike. One of the few identifiable objects on our property. There we go. All right, late March 2004, we hired a builder. So we cleared, we finally hired a builder. Yay, good. August 2004, our foundation was poured. It was a good day. October 2004, our framing was underway. All right, let's skip one. January 2005, starting to look like a house. March 2005, even more looking like a house. And finally, July 17th, 2005, was the day that we went home, 21 months after our fire. And here we are today. On the one hand, I hope that this is hopeful to you. On the other hand, I know that some of you probably feel a little sick right now. You're like 21 months. When my own house went down and I was in the Red Cross Disaster Recovery Center, I remember speaking with a Red Cross worker, and it was the first time somebody told me how long to expect. And I might get a little choked up even now, just even thinking about it. And I remember she told me, she goes, because I asked her, I said, what should I be expecting here? And she said, 18 months to 3 years. And I remember my daughter had just started 2nd grade, our house burned down in the fall. And I remember thinking to myself, she's going to be in 4th grade? I felt like somebody had sucker punched me. I felt really sick and nauseated, to be honest with you. And let me just say, it varies. But looking back at what I've seen in these disasters, community to community and state to state to state, I think that 18 months to 3 years is a very reality-based estimate. Some of you will be faster, there's no doubt. Have I seen people back in a year? I most certainly have. Absolutely. So it's absolutely possible. But I think one thing that will help you in the long term is to start to kind of try to come to peace and kind of come to grips with reality-based what you're looking at for a timeline. It's a marathon, not a sprint. You guys, here's the good news. Here's the end, and it's coming. So just hold on. You're going to make it. All right? We did not rebuild the same house. It was actually cheaper. We had to rebuild it in our community, which was very unique. It was the first of its kind in the U.S. So it was actually cheaper for us to build a different house. We had a group rebuild program. But, you know, again, a lot of variables. Some people can make it back faster, but again, you know, it's a process. You guys are all going to get there. So just again, just hold on. And every single time, you know, you just take a step forward, celebrate along the way, you know, every little piece. All right, because I'm going to move on to our next speaker, which is Thomas Henderson. Tom is an attorney with Berg Simpson with a ton of experience. He has been a guest speaker for Roadmap to Recovery multiple times in 4 Mile, in Pine Park, and Waldo Canyon, really volunteering his time tirelessly. So I thank you very much for making the drive yet again, Tom. He's going to talk to us about California. Try that one more time, my friends. He's a busy flight this morning. Colorado claims handling rules and regulations. So I turn it over to you.
Good evening, everybody. As Karen said, my name is Tom Henderson, and I'm a lawyer at Berg Simpson firm in the southern part of Denver. And I have the unfortunate pleasure, I guess, of having spoken to a number of groups of people just like yourselves. As Karen mentioned, I have spoken to 4 Mile folks, which was Labor Day 3 years ago up in Boulder. I have spoken to Hyde Park folks up in Fort Collins area. I've spoken to Waldo Canyon folks. I don't need to tell you where that is. And now I'm here. And I wish I could say that I thought this would be the last group I'll speak to, but unfortunately, I'm rather certain that it will not be. So just a very brief little something about myself, about my firm. Some of you may hear our ads either on TV or on the radio, Home Runs for Rockies, which unfortunately there's not very many of those these days. Law firm with over 35 years experience in insurance litigation in Colorado region. The Denver office, which is where I practice, we have over 20 lawyers there. We have offices in other locations as well. And then a little bit about me. I've been at this for 26 years, long before I had these gray hairs, all doing insurance litigation. The first 20 years of my practice, interestingly enough, I worked for the insurance companies. So I like to say I know how they think, and sometimes I know where they need to get to before they figure out where they need to get to. I now work exclusively for policyholders, so for the last 6 years of my practice, I represent people like you, and businesses, and other entities that have suffered wrongly at the hands of the insurance companies. I specialize in first-party insurance claims, which is exactly what you have. You're looking to your homeowner's policy. You're not looking to somebody else's policy. If you get rear-ended on I-25, that would be third-party insurance that you're looking for, because you're looking for the other guy's insurance. But your insurance is first-party. And along those lines, a whole series of duties and responsibilities, which is what the bulk of the program is going to be about. I'm a trial lawyer, so I have experience in the courtroom, and I have good success. All right, what's the source? Let's get into the meat of that. The source of the duties and responsibilities. And I like to call this presentation, or when I was thinking more about it, this is know your rights. Know what your rights are. Because a lot of people, particularly people where you're sitting right now, you're completely overwhelmed by the process of the insurance company. And the insurance company oftentimes seems to be dictating to you how this process is going to proceed. So it's important for you folks to understand what are your rights. There are laws out there that an insurance company is obligated to comply with. And I'll give you a few little pointers, but tonight is mostly about understanding and knowing what your rights are. Also, all of these slides will be on UP's website, and Karen will probably reiterate to you where you can find that information. So I'm going to be spitting a lot of information at you. Know that while you're certainly free to take notes, it will be uploaded onto their website shortly. So the source of the duties and responsibilities, first and foremost, is the insurance policy. It's a contract. So I'm going to go into, in a moment, what those rights and responsibilities are going to be under the insurance policy. About the only other place you're going to find a source of your rights that I'm hopeful that you will come away knowing, at least some semblance of is Colorado statutes, laws passed under the Gold Dome. Case law, that's judge-made law. Division of Insurance Regulations and Bulletins, and that is a subdivision of the Department of Regulatory Agencies in Colorado known as the Division of Insurance. So, the insurance policy, the obligations under the contract. So what is the insurer, that's the insurance company, what are their duties and responsibilities? And this is just a broad overview. They have a duty to conduct a reasonable investigation and do it in a timely manner. They have a duty to pay what is owed in a timely manner with no strings attached. I'll get into a little bit more into that in a short bit. Last, at least for this purpose, is to let the policyholder know what information is needed and in what form. So the insurance company, and you have a right to ask your insurance company, I don't understand what it is that you need to be able to consider my claim. Please tell me. Please tell me what I need. So it sometimes is like that movie, I'm not going to come up with the name of it, but Help Me Help You. Help me help you get you the money that you need. So, Mr. Insurance Company, tell me what you need to be able to fairly and properly evaluate my claim. Well, it's a two-way street. You have responsibilities as well. So, you have a responsibility under the insurance policy to respond to requests for information, including providing inventories if requested. I get more complaints from people saying, why do I have to fill out this silly inventory than just about anything else? And the unfortunate reality is that within the insurance policy, there will be a section that says if the insurance company asks you to do it, you got to do it. Karen has provided some information, UP has provided some information that will assist you in filling out those inventories and providing that information, but there's really no way around actually sitting down and having to undertake that process. The second duty that you have, if the insurance company requests it, is to interview you, and most of them have probably already done that. They're allowed to take tape record statements, but only if they ask your permission, and you have to give them that permission. And normally that involves putting the tape recorder or mini tape recorder right on the table in front of you. Also, and this is quite a bit further down the road, but I'll tell it to you now just in case, there is a process that is allowed under the insurance policy called an examination under oath, also known by the acronym EUO. And that's if you and the insurance company are kind of at loggerheads with respect to certain matters, they can ask you to sit, take an oath, and then they will ask you questions and you have to respond to those questions. Strongly advise if you get to that point that you consider legal representation. Also, you need to comply with various timelines in your insurance policy. Pay attention to these timelines, folks. Even though you're only 60 days out, almost 2 months, nearly 60 days out, there are timelines. Some of you may have timelines, and it varies policy to policy, company to company. Just because your neighbor may have Allstate and they have one set of timelines does not mean that your Allstate policy is the same, or State Farm, Farmers, USAA, American Family, or Liberty Mutual, whatever it may be. So, walk through the timelines. Ask your adjuster to let you know what's in the timelines. Generally speaking, those timelines will include things like how long your additional living expense, your rent payments that they are paying for, will last. Some of them are as short as 6 months. There are other timelines, such as how long do you get to tell them that you want to replace? How long do you have to actually complete replacement? All these are really critical timelines that you need to kind of keep in the back of your head, and maybe even make a note on whatever calendaring method that you use, just to kind of keep an eye on, because those things will creep up on you. All right, the law. So that's another source of insurance company obligations. And number one is Colorado Unfair Methods of Competition and Unfair or Deceptive Acts or Practices. And the CRS, that stands for Colorado Revised Statute. This will be on their website, UP website, 10.411. H, and unfortunately, it doesn't say what an insurance company should do. It rather says, here's what an insurance company should not do. So among the various things an insurance company should not do is misrepresent pertinent facts and insurance policy provisions relating to coverages at issue, failing to acknowledge and act reasonably promptly upon communications with respect to claims. Colorado, unlike some states, does not have any firm timelines that an insurance company has to respond into a regulation at the moment. But that doesn't say they have to respond to you within 15 days or within 30 days. So that segues into what Karen was saying earlier about give them a time. And don't make it 3 days. Make it as Karen calls it, commercially reasonable time. 1 week, 10 days, 2 weeks, whatever it may be, to respond to you. But they do have to respond to you. They're not allowed to ignore you. And it doesn't matter how many claims that particular adjuster has. It doesn't matter how many other homes they may, or how many other building sites they may have visited. That does not alter their responsibilities. And insurance companies do bring in what they call catastrophe teams to situations like what you guys experience, where they will bring in, it's basically all hands on deck, where adjusters will come from all points. So don't allow them to say, oh, I'm just so busy, I just can't get to it. That doesn't cut it. More of the Unfair Claims Practices Act. Refusing to pay claims without conducting a reasonable investigation based on all available information. Why did I italicize all available information? I italicize that because you can bring them information. It's not solely the insurance company who has a response or who can go out and investigate. You can bring in information. If you don't like what their contractor, what the adjuster's rebuild price is, guess what? You can go get information yourself. Talk to some of your friends in Waldo Canyon and find out what contractors did they use. Go get a bid from that contractor. What it would cost to replace your home. And you supply that information to the insurance company. Insurance companies don't like to tell you that you can bring them information. They're not the sole decider of where that information comes from. They have to, they are obligated by the Unfair Claims Practices Act to pay attention to any information you bring them. Not attempting in good faith to effectuate prompt, fair, or equitable settlements of claims which liabilities become reasonably clear. Well, I dare say that most of you in this room, there's no question about the fact that they're liable. I went into that sometimes in different types of claims. So, they are obligated to act in good faith, to try to act promptly and fairly for you. And I bring up all these things because for most of you, unfortunately, there will come a time where you're going to be yanking your hair out and you're going to say, how come this insurance company is doing this to me? And then you're going to remember, hey, I remember this lawyer from Denver, Tom Henderson, speaking to us, and it was at United Policy Holders, and there might be, he rattled off a bunch of stuff about the Unfair Claims Practices Act. Go back and find this presentation on the outline, and then you can spit back to the insurance company in a politely assertive tone many of these various different provisions. When an insurance company pays you, cuts you a check, they have to tell you what that's for. Oftentimes, insurance companies will give you an advance, and they still need to tell you what's that, under what coverage is that advance for. Is that under my coverage A for my dwelling? Is that under coverage B for other structures? Is it under coverage C for contents, personal property? Is it under coverage D for additional living expense? What coverage is it under? They have an obligation to advise you of that. Don't let them say, oh, it's just kind of a general thing. They are obligated to adopt and implement reasonable standards for the prompt investigation of claims. They do have an obligation to settle claims where liability has become reasonably clear, but they're not allowed to dangle as a carrot settlement under one part of your claim in order to settle a different part of your claim. For most of you, your claims, as Karen mentioned, are going to be handled kind of in parts. There's going to be your dwelling coverage, or coverage A, or whatever your particular carrier refers to proceed at its own pace. And then there's going to be coverage B, which usually is other structures, and that typically goes hand in hand with coverage A. But coverage C, for personal property, that's typically on a completely separate track, as is the additional living expense coverage B. So don't let the insurance company try to dangle carrots in front of you that, well, one part of the coverage needs to hinge on how another part of the coverage is progressing. There was a new statute that was passed, led by folks who are sitting in rooms not dissimilar to this one, from 4 Mile, High Park, and Waldo Canyon. And one of the leaders of that effort, I see seated in the back, who was a Waldo Canyon survivor, Steve Price. And that was a piece of legislation that was signed by Governor Hickenlooper on May 10th, called the Homeowners Insurance Reform Act 2013. One part of it is already in effect, and so it applies to you. The rest of it, unfortunately, does not, but will take effect kind of progressively, but ultimately for policies issued after January 1, 2014. The part that has already taken effect is oftentimes in your insurance policies, there will be something that's called a suit limitation clause. And that would have applied to you, except for the fact of this statute. And that said, typically, you have 1 year to sue us, so says the insurance company, even if you don't have any disputes against them within that 1 year time frame. And I could recount a few horror stories. I also represent a number of folks who were harmed in the Lord Fork Fire, which was the fire up near Concord that was set by the state of Colorado, killing 3 people. And in that situation, some of the people didn't yet have disputes against the insurance company, but we had to proceed forward and file a suit. So, the good part of it about this piece of legislation is that it eliminated any suit limitation clause shorter than what Colorado's statute of limitation would otherwise be. 3 years for contract, 2 years for tort, which is bad faith. Don't allow an insurance company to try to intimidate you into believing that that does not apply to your claim. It does apply to your claim. So the suit limitation clause does not apply because of this piece of legislation. It does apply. I have heard rumor out there that some insurance companies intend to try to challenge the constitutionality of that claim, but the law is the law is the law is the law until it changes, so that remains the law in Colorado. There is another statute that was signed into law in 2008 that requires that insurance companies not unreasonably delay or deny payment of a claim for benefits. That seems self-evident. But insurance companies would get away with it, and then they try to pay you at the very last minute, essentially claiming no harm, no foul. So eventually, after much effort, the legislature passed a very consumer-friendly law that says insurers cannot unreasonably delay or deny payment of a claim for benefits owed, meaning that they can't delay payment. For most of you, I suspect there's not going to be denials of payment, but they are not allowed to delay payment without a reasonable basis. Now, it's kind of edgewords there, a reasonable basis. What's a reasonable basis? Well, they need to be able to tell you. You have to ask them, what's your basis for not paying this claim right now? And then they need to give you a straight answer. If they don't give you a straight answer, confirm it in writing. This confirms that I asked you on such and such a date, on your claims diary, such and such a date, to please advise as to why it's taking so long to pay my claim. And your response was, you didn't know, or you refused to tell me. Please reconsider and give me a prompt written response within 2 weeks of time. What makes this particular statute appealing is it's got teeth to it, which is if an insurance company does not, or if an insurance company does unreasonably delay or deny payment, they can be responsible for up to 2 times, so a penalty of 2 times that covered benefit. And they can be responsible for attorney's fees and costs. So that's something for you to kind of keep in your hip pocket in the event that you need to whip that out at some later point in time. All right, there also are regulations for produced by the Colorado Division of Insurance. You can find these on the DORA website, which is the Department of Regulatory Agencies. Go to the colorado.gov website, or you can just type in Division of Insurance, and you'll be able to navigate your way through. Keep trying. It's not a very simple site to navigate. You find these various regulations. This regulation, 5-1-14, says that an insurance company must take certain action within 60 days. However, it's a big however. There's a whole lot of legal words in this regulation. So the unfortunate reality is that it is oftentimes not as useful as I and others who do what I do would like it to be. Nonetheless, it says an insurer has 60 days after receipt of a valid and complete claim to make a decision and pay unless there is a reasonable dispute. The insurance company will say, well, I have a valid and complete claim, and there's a reasonable dispute. But again, ask your insurance company, what do you need from me? What do you need from me? The insurer must give notice to you, the policyholder, of any reason for delay of payment and notifying the need for additional investigation and must keep the status updates every 30 days. That one is one that I think is very, very useful to me, which is every 30 days, the insurance company is supposed to send you some kind of a status update. That means in writing. So if they're not doing that, ask them, Chief, I was at this presentation, I heard a lawyer talking, and he was talking about some insurance regulation that says every 30 days you have to give me an update. Will you please provide it to me? And then follow up with an email that confirms that on tomorrow, August 2, I requested my 30-day status update. I look forward to receiving it within the next week. There also are cases. This is judgment law. Every contract in Colorado includes an implied duty of good faith and fair dealing. In so many words, good faith is a promise by the insurance company to always act fairly toward you, and a breach of this duty gives rise to a separate legal claim, which is breach of the duty of good faith and fair dealing, also known by its converse, bad faith. There's an important piece of information for you guys to take away, which is that first bullet point there. There is a case law decision, Dupree versus Allstate, from 2002, decided by the Colorado Court of Appeals, that makes a distinction between replacement cost and reproduction cost. That becomes really important when you're talking about your ordinance and law coverage, which oftentimes is called code upgrade. Your policies probably include exclusions for code upgrades, but oftentimes there's going to be some limited amount of what I'll call grant-back coverage for code upgrades. The insurance company, if you have a total loss, the insurance company is not allowed to use that ordinance and law sub-limit of coverage to try to cap what they owe you. They can use the actual limits for your coverage ending, but they can't use that sub-limit for code upgrade coverage, for your ordinance and law coverage, which oftentimes is going to be a certain percentage of what your overall policy is, to say, well, you maxed out on your code upgrade coverage, which comes into play if your house was built some number of years ago, and in the meantime there's been some changes in the building codes, such that now it will cost a lot more to reconstruct certain portions of your house. Oftentimes it's wiring or plumbing or certain types of wind requirements for the roof or whatever it may be. So cite to them, to this Dupree versus Allstate case, that reproduction cost is putting it back as is with all faults. That's not the coverage that most of you have. Most of you have replacement cost coverage, which means I need to be put back into a house in which I can live. That's replacement. That's what you're asking for. That's what you bought and paid a premium for. Another issue that oftentimes comes up is underinsurance. And that's, many of you may think, well, gee, how come my agent didn't tell me about this? The fact that I did not have enough insurance to pay to completely replace my home. Folks, Colorado law is not very favorable. And I may be back out here talking to probably a somewhat smaller group several months from now to rehash this point, but just know that if you are looking to sue your agent for negligently failing to procure enough insurance coverage for you, that's a steep road to hoe. All right, regulations versus bulletins. I put this up because I'm now going to flip through a couple of bulletins. Bulletins are not binding on insurance companies. And these are also produced by the Division of Insurance, but they are merely the Division of Insurance's interpretations of existing insurance law, but they establish neither binding norms nor firmly establish the rights. All right. This was a bulletin that was passed after the 4 Mile fire, and unfortunately it's been watered down considerably since the 4 Mile, or since immediately after the 4 Mile fire. But after forest fires, the Division of Insurance encourages insurers to consider. So again, kind of frankly rather milquetoast type of language, but still can be useful for you to say, hey, this insurance regulation or bulletin B.5.28 says that you should advise me of how long my additional living expense coverage is available to me. Why is that important? That becomes important because if you have timelines for completing certain things, then it's really important how long your additional living expense goes on for. It's going to take you longer than a year to rebuild. Then you need to start now talking to your insurance company about what do we need to do to try to expedite this, because I only got 1 year of additional living expense. And per this bulletin, they should be thinking about these things. The Division of Insurance has not yet said that they have to be in that regard. The second bullet point is critical, and again, that becomes, it's tied into your knowledge of what your timeline is. They should consider, as I said they must, they should consider policyholder requests to extend the time to replace or rebuild if you've made a good faith attempt to adhere to the policy provisions and request an extension before the deadline expires. There will be probably another one of these presentations that will, as you're coming up on the 1-year anniversary, that will remind you of many of these things. But it's just important to keep in mind what those timelines are. Here, there's a shall. Shall means insurance company should, even though the bulletin language is a little different. They shall make reasonable attempt to settle claims promptly so that you can rebuild your dwelling in a timely manner and replace your personal property. This is another really important thing from this particular bulletin, which is they should consider other factors affecting the cost to rebuild. Folks like you who have suffered a mass scale problem, guess what happens to the cost of labor? Guess what happens to the cost of materials like sheetrock and other things? Through the roof. So that needs to be considered by the insurance company when they're figuring out what's the cost to replace your stuff. You can't get it just from a little computer program that they like to use that does not take into account all these items. There's another bulletin that Karen's advised me I'm running out of time, so I'll scroll through a couple of these. Appraisal clause. There is a provision in the insurance policy that says if you and the insurance company are at loggerheads over what's the value of something, you can request appraisal. And under this particular bulletin, the appraisers have to be fair and neutral, so the insurance company can't use their pet that they use day in and day out for that type of claim or for appraisers. Insurance companies, so this is kind of my sum up here. Insurance companies must treat you fairly. They must help you understand your policy. If your adjuster comes to you and says, well, you're required to do this, or I need you to do this, ask them to do one thing. Ask them to pull out your policy and point to where in your policy to say that you're required to do that. Ask them to do it. And if they don't, say, well, who can I talk to at the company that will point me to where the insurance policy is required that I have to do this? They, let's see, must respond to your communications timely, pay what they admit is owed with no strings attached. Once they admit that something is owed, they have to cut you the check. They can't tie any strings to that check. Does not mean that you have to accept what they are cutting you the check for. You can still dispute it, but they're not allowed to say, I'll only give you this check and sign a release. They can ask for a receipt, but not for a release. You are not required to accept the insurance company's valuations of your dwelling, other structures, and personal property. You can go out and value it yourself. You can go get a contractor to give you his or her own opinion as to what it would really cost to replace your dwelling. So consider hiring your own contractor. Insurance companies must give written explanations of all payments made. Insurance companies must give you copies of the estimates on which they base their payments. If they don't give it to you, ask for it. If you ask for it, they have to provide it to you. And document. That gets back to Karen's mention of making a claims diary and following up with politely assertive emails. Know your rights. If you need an attorney, make sure it's someone who knows what they're doing in this arena. And there's part of the violence of our citizens. So, thank you.
A lot of information in a very short amount of time, so thank you for just giving them that introduction and a lot of valuable information. Some of that you might just be thinking, hey, it's going smoothly now, and again, we hope it goes smoothly the whole time, but this is the kind of information you need to just have. So if you run into hitches, you've got some information at your disposal. I want to bring up my next speaker, Mr. Scott DeLuise. Scott DeLuise is a licensed public adjuster. He's going to be giving us some tips, information on documenting your claim. Thanks so much, Scott. Again, Scott's been a speaker in Road now in Fort Mile, in Hyde Park, and thank you for being here tonight.
Thank you for inviting me tonight. I know it seems like you're drinking through a fire hose, but you will get through this. Like Tom, I've been practicing for 26 years. As a matter of fact, when I was a young public adjuster, Tom and I sat across from the table, sat across the table from each other numerous times. We are still friends to this day. And I appreciate him coming up for me. So, yeah. Thank you. So my company is Matrix Business Consulting. I'm not going to plug the company because you guys are going to find out much more about what the claim process is like as you go through this. So I don't need to talk about anything other than claim documentation, finding experts to quantify and evaluate the repairs needed. Now we're talking about partial losses, and we're talking about total losses. It's interesting to note that partial loss claims are the most difficult to get properly paid. And they have the lowest return on investment for time invested. This is a very difficult process because this is the area in which insurance companies find it most debatable. When your house is burned to the ground, it's really a valuation process. How much was it worth? How much were my contents worth? How long am I going to be out of my house? When you talk about total loss or partial loss claims, it's, was that window really damaged by heat, smoke, fire? Was my roof damaged? Do I have cinder burns on my siding? It's a lot of work to prove this, and hopefully tonight the takeaway will be that you have resources that will help you get there. Total loss claims are the highest value, and it takes the longest time to get paid on any kind of a timely basis. Again, proper documentation. Boy, I'm not very good at this mic. Proper documentation is the most important thing of all. And every speaker standing up here has said that, and I'm going to say it again. If you properly document your claim, it will shorten your period of recovery, and it will maximize that potential recovery. So keep that in mind constantly. It's your duty under the policy to prove your damages to the insurer. You might ask, well, why does the insurance company even have an adjuster here if it's my duty to prepare the claim? Well, when you think about it, it only makes good sense. They want to control the horizontal and vertical. This is all about money, and they're very experienced at preparing claims for their policyholders. But it's your claim, it's your home, it's your money, and they have it. And the goal is to accurately assess your damages and present them to the insurer so they'll pay it on a timely basis. If you allow the adjuster to prove your damages, they may not find all of those damages. They're not trained to find all of the damages. They're trained to get through these claims. They're trained to get through them as fast as possible. And it's only good business sense that they're going to pay the least amount that they can legitimately pay and not upset you to the point where you have to visit those members. In order to obtain all of the benefits under your policy, you must create your own advocacy. As every speaker up here has said, get in the middle of this process. Don't let the insurance company do it for you. It's imperative that you be proactive and you help prepare your family. As you'll learn through the Roadmap to Recovery series, documentation is the key to successfully obtaining the benefits you're entitled to. Every loss is different. No matter, yours is not the same as your neighbor's, so no matter how similar the damage is, you should be collaborating with your neighbors, but don't fall into the trap of, but my neighbor got this, my neighbor got that. It doesn't matter. Your loss is unique, even if it's the same insurance company right next door to your neighbor. If you have a total loss, you might retain a well-respected contractor up front because you will need a comprehensive lifetime and quality, detailed estimate of your damages, right down to the quality of finishes, new for old, and that's the definition of replacement cost value. New for old, lifetime and quality. So here's the bad news. Typical adjuster cost per square foot, and these are Waldo Canyon examples. We haven't seen yet what's going to happen here, but I would surmise that it would be similar. $150 to $180 replacement cost per square foot. Typical quality contractor cost per square foot in Waldo Canyon, $220 to $300 a square foot. If you have, well, so the note on that is if you have a, my notes aren't here, but if you have a 2,000 square foot house and you have $150 a square foot difference from your adjuster, that's a $300,000 difference in the value of your home. So be prepared to discuss those issues with your adjusters. If you have a partial loss, proving your damages will be much more difficult. Depending on the severity of the loss, the insurance company will fight like crazy because they don't want to set a precedent for, but my neighbor got. Don't ever say that to an insurance adjuster. You might find that the adjuster's damages are less than those an expert chosen by you will identify. In fact, most of the time you'll find that when you bring your team, the damages will be different. Estimates are estimates. Everybody's going to be a little bit different. That's why the bidding process happens out there. And as an aside, I would not encourage you to get 3 bids to replace your home. Find a contractor that you know and respect. Connect with that contractor. Have him prepare your estimate of damages. Stick with him. Help him defend his estimate to the insurance company. Because if you get 3 bids, what's the insurance company going to do? They're going to take the lowest bid every single time. You don't want that to happen. You want the most qualified bid, and you have the right to choose your own contractor. So do it early, and get a good one. Smoke contamination to your dwelling and contents. You may need an expert to prove smoke damage. Now, what we found in Black Forest is that the insurance companies are bringing in restoration contractors to clean these houses if there's any hint of smoke. If the smoke got anywhere on your property or near your property, that's good. The problem is that, again, they're controlling the horizontal and vertical. They're working for the insurance company. We have a couple of clients here who the insurance company sent a cleaning company in. They didn't even see the check from the insurance company to the cleaning company. It was a direct pay. I'm not a big fan of direct pay because it's your home. You deserve to pay the contract. No insurance company should be paying any of your bills except through you, because if you're not satisfied, you don't have to pay the contractor until you are. Heat damage to exterior and interior dwelling. Visible melting, spalling, window fogging, cinder burns. All my friends who are volunteers here from Waldo Canyon know these stories. Invisible brittleness shortens the life of the building component. You may not even see it, but you could have cracks in your stucco. If you have stucco siding, you could have, on a log home, your chinking could be damaged by heat. Resources, look on the UP website for links. I do have some a limited number of sheets here that are recommendations of some select type contractors that can help with partial losses, like window experts, restoration contractors, et cetera, et cetera. They're not my references, they're not United policyholders. These are from our friends in Waldo Canyon that had good luck with these people. Smoke identification. You may need an industrial hygienist. You may need an industrial hygienist. If your home was filled with smoke to the point where you have black soot coming out of your light switches and outlets, chances are you've got smoke inside the walls. It could mean big problems later if that smoke is not removed. We saw a number of homes in Waldo Canyon where the homes had to be gutted. The walls were still standing, the interior framing was there, but the smoke was so pervasive that the entire house had to be gutted. Don't get caught without having that investigated if you have serious smoke damage. Some carriers will pay, depending on the severity. Some carriers will say, no, you may need to retain your own. Always be present so you can take notes. Ask the hygienist questions. Where are you taking these samples? Why are you taking it here? Be sure to take a sample. See those cobwebs up there that have smoke on it, that are black. Cobwebs that are black don't come from black spiders. It comes from smoke and soot. Test in hidden places, because smoke pressurizes. You will find that there's a temperature and pressure differential between the inside of the house and the inside of the walls when the smoke comes through. It can push that smoke right into the walls. It can push it out of the walls. It has to be tested in places. You may have to do some destructive testing where somebody cuts a hole in the sheetrock and somebody takes a tape sample, a tape lift from inside the ceiling. Different testing methodologies may be appropriate. Air sampling, that's where they come in and they this little puff smoke into a cylindrical filter. They leave it there for 12 hours. They measure it. They tell you how much smoke is in the air. A lot of that's going to start going away. It doesn't take very long for that to happen. Tape lifts, that's where they will actually lift the smoke off of a vertical surface or horizontal surface, and they'll send it into a lab for testing. And then the big one, the expensive one, is quantitative analysis, electron spectrography. That is the word. Exterior building damages. Don't lose credibility. Do not overreach ever with your insurance company. Now, there may be a difference between what you believe the damages are and your insurance company believes, but when you know what your damages are, don't overreach. Don't ask them for more than you're entitled to, because you'll lose credibility, and that's what really makes it difficult. For soffits and fascia, warping, smoke stains, sap, peeling paint, sap on wood. When wood gets too hot, sap comes out of the wood. Walk around your home. Look at the paint. See if you've got any sap coming out of the wood. If that's the case, that wood is damaged and it needs to be replaced because it's too dry. Windows, vinyl windows, efflorescence, that's the white stuff that you can get off the white vinyl and you look on your frame and go, wait, what happened to my windows? Warping, shrinking stops, staining. Tom and I handled a really serious fire in 4 Mile Canyon where the insurance company refused to acknowledge that the windows were damaged when we proved to them that the seals on the windows got so hot that they curled and they were letting smoke and soot go into the house. That one took a long time to get settled, but it was very effective in the end. All windows, warped, shrunk seals, look soot on the sills, photo document everything. Clean, watch for more soot. Go change the air filters in your furnace. Does anybody here not change the air filter in their furnace? You want to change it right now. You want to keep that filter because I can tell you it's going to be black. And then you want to put it in and measure another 30 days and then pull it back out and look at it again. If it's gray or brown, be sure and keep track of how long it takes for it to lose its white color. Other structures, detached garages, fences, retaining walls. They're covered most of the time at 10% of dwelling limits. That would be your coverage B. Only fences are actual cash value. And that's only on some policies, but you're going to find that that's the majority of them up here. They don't like paying big money for fences. Landscaping. Most policies have 5% of dwelling limits coverage. If fire came on your property, most likely trees, lawns, shrubs, replacement cost value will exceed these limits. Ask for a check if it's not offered up front. If your lot has extensively burned trees, I don't care what the policy limits are, they should write you a check for that 5% right there on the spot. And you can use it for whatever you desire. Please look on the UP Health website for other resources. Industrial hygienists, smoke mitigation contractors, restoration contractors, fenestration experts, those are window experts. Wildfire smoke white papers are on the UP website as well. So thanks for coming tonight. I went through it really fast because I wanted to have plenty of time for Q&A. I'm sure Tom wants to answer questions. Karen, I'm sure wants to answer questions as well. So keep in mind, knowledge is power. The more you come to, the better off your results are going to be.
Thank you, Scott. Thank you so much. All right, everybody. We're going to go for our Q&A. Commissioner Middleton is very graciously offered to help us. We have a single microphone, but we're, again, just going to rock it out. We're just going to go with it. So Commissioner Middleton is kindly going to, if you want to raise your hand, she's going to walk the microphone to you. Thank you for doing that. And then she's going to bring it back up to us. You can direct it to a specific person, or if it's a general question, any of the three of us will take it, whoever we think is important. Thank you. So if you just have raise your hand, she'll come on over to you.
My question is for the attorney. Question is to the attorney. You had a slide when you started talking about it and you switched. There was one about if you chose not to rebuild or replace.
The question is, there is a Division of Insurance bulletin that talks about if you decide not to rebuild or replace, can the insurance company deduct for a contractor's overhead and profit, which is typically a part of the equation for computing replacement cost. And this Division of Insurance bulletin says that if you have replacement cost coverage, but for whatever reason you decide not to rebuild or replace, the insurance company is not permitted, again, it's a bulletin, not a regulation, but they are not permitted to deduct for the contractor's overhead and profit when they compute the actual cash value payment that is due to, that was the slide that I blitzed through quickly, sorry about that.
We'll go back and forth.
Correct. Yeah, actual cash value, which is your ACV. Correct.
My question is about older homes here who have popcorn, fumes, asbestos, and options for removing those. Insurance company. Partial, yes. And also, is the code upgrade have, is that part of the code upgrade, or is that just
That's a great question. I probably should have covered that in mine. Colorado Department of Health regulations require that if a demolition contractor or another contractor runs into a situation where that popcorn ceiling has to be replaced, they are required to test it. The insurance company is required to pay for that testing. If they tell you no, they're not giving you the straight story. A lot of insurance companies recently have been saying, no, we don't pay for that. Yes, they do. And if it has to be removed, it's expensive debris removal. That's how you explain it to the adjuster.
So, my case, I don't know.
All right, well then you need a industrial hygienist to come and test it, prove it to the insurance company, and then they'll write a protocol for abating that asbestos. No, the insurance company, you have to submit a claim to the insurance company, and then you can demand that they pay for that asbestos mitigation.
Also, in order to handle asbestos, whoever does it needs to be licensed through the state. So don't allow, if the insurance company wants to have a one-size-fits-all contractor or restoration company come in and do that work, it's okay so long as they're licensed, but you need to make sure that they are licensed in order to be able to do that. I could cite a number of examples where they weren't, and they take a bad situation and make it a whole lot worse because they don't know what they are doing. So it's guys in spacesuits running around taking care of it.
Do the percentage coverages, like the 5% for landscaping or whatever, apply to extended coverage or only to the basic coverage?
Another good question. It just applies to the base coverage as far as I know, unless your policy reads differently. On the one hand, on the other hand, I sound like a lawyer.
I know a lawyer, and he would tell you it depends on the language of the policy. Scott's right that the majority of the time the percentages are not going, the extended coverage is not going to kick up those percentages. But I have scrutinized policies, and there have been a couple of times where I've been successful in getting insurance companies to pay more because they may think they know what they said, but oftentimes they don't. And that's what you need to tell them.
On the landscape issue, we had a forestry service come out and look at our property, and basically the guy said, well, you won't know next spring whether some of these trees live or die. So you wait till next spring to file the claim to get your 5%, or you call them out now and get a claim adjuster to kind of walk through and look at stuff, or what's the best way to go on?
I honestly think that if you're that close on the coverage for your trees, shrubs, and landscaping, based on your policy limits, that you ought to have an arborist come out and give you a professional opinion. If the trees are damaged, they owe you to replace the trees. They don't have to be dead.
We have a case of underinsurance. Are there any factors that will play into our favor of the argument?
We have a case of underinsurance. Are there any factors that will play into our favor when we're negotiating that?
As I mentioned, underinsurance is a widespread problem, and it's virtually impossible to get the insurance company to agree to reform the policy. However, if you had what's known as a special relationship with your agent, then there is a potential for argument. What's a special relationship? Well, it's more than just I sat down with my agent every year, or the agent would send me a renewal every year. So what you need to do is try to get back and look at, or ask your agent, and try to enlist your agent to be your helper, to be your best ally there. So ask the agent to review the original application. What was the information that was submitted in the original application? Ask your agent, how did you come up with the dollar amount to that were going to be my limits? Because for the vast majority of you, your limits were probably established when you closed your home, and all you cared about was that you had enough limits such that your mortgage company would allow you to close, and all your mortgage company cared about was that you had enough limits so that their number one security, which was the home, was covered. Well, that is in relation to what's the amount of the mortgage and what's the fair market value of your home. Fair market value does not equal replacement cost value. Replacement cost oftentimes is significantly more than fair market value. So go back to your agent, talk to your agent, try to find out from him or her, how did you go about computing the amount of my coverage, and don't let them tell you, or the insurance company will tell you, you didn't decide the amount of coverage, you decided the amount of coverage, which we all know is quite frankly a fiction, but that's how the insurance companies will, that's what they will tell you. I also know of one situation where a potential client came to me and said, you know, I was able to get the insurance company to send to me the underwriting file, which is the file back at home office that is where your application lives from the insurance company side rather than the agent side. And able to figure out that what was used by the insurance company to calculate the amount of limits for that person was information that was pulled off a El Paso County Clerk and Recorder's Office document based on the square footage of the home. The square footage of the home on the El Paso County Clerk and Recorder's Office was wrong. It was grossly wrong. It was way less than what it should be. And I don't know that we were ever able to figure out who, you know, it was what garbage in led to that problem, but the insurance company relied on that. But good luck in terms of trying to get the insurance company to send you that information. If they do, then I would flag that to them. I would say, look, it was garbage in, garbage out. The original garbage in here had an inaccurate square footage amount for what my home was. And it should have been X, not half X. So please, and the magical words to ask for is to reform. That's to kind of go back and recreate. Reform the policy limits to be what you think that they should be. Enlist your agent for help on that. And if the insurance company is willing to reform, and there have been some instances, I had a couple of instances after 4 Mile, where the insurance company was willing to reform the policy under very, very strict secrecy. So I can't tell you what the names of the companies were, but they're companies that are common company names. But they didn't do it for everybody. They asked them to reform the policy. They are entitled to charge up whatever the higher premium would have been for that higher price, but that's a very fair trade.
Let me just add to that underinsurance in UP's experience is one of the most pervasive problems after these natural disasters. Some of you may be underinsured and just frankly don't even know it yet because it sometimes takes time to even realize that you're underinsured. You may not have gotten the scope of loss from your insurance company yet on the dwelling. You may not have had your own contractor quantify. So again, I'm so glad you brought it up. It's a very, very common problem. I was underinsured. A bunch of my neighbors were. It's a very common issue. If you want to educate yourself even more about underinsurance, UP has a whole section of the website about underinsurance. So in terms of just understanding what the problem is, you can review statistics from previous wildfires and see how pervasive this issue is. But as Tom said, it's a pretty tough road to hoe. So, but again, educating yourself about the issue and just knowing it's been a pervasive problem, disaster to disaster to disaster, is an important step.
I still got, I requested on several occasions a copy of my actual policy, and we're 7 or 8 weeks from the fire, and I still have not received my policy. I received the check for my dwelling because I own my home outright, but I still don't know what exactly is in the contract.
Requested it in writing? Okay, put that request in writing. And would you do that letter or that email? Then follow up and just, again, keep laying that paper trail of you're making that written request. And every time you communicate, summarize your previous communications on such and such date or on such and such dates. Do you see what I'm saying? The more they see that you're keeping track, the more incentivized the company will be to do what they're supposed to be doing. Do you understand?
You're not alone. I bet there's at least another dozen people in this room who have suffered from the exact same thing. And it happens again and again and again. One of those new pieces of legislation that passed that unfortunately does not yet apply to you does give insurance companies a particular amount of time that they have to provide your policy. But ask the insurance company, and you do it every other day, and ask for a certified copy of the policy also. Now, just because they give you that they certify it does not necessarily mean it's right, so you're still going to have to check. I had a client in 4 Mile, and they sent them the wrong edition of the policy about 5 times before they finally got it right. Because the dates for coverage were not the right dates. If you look on the very first page, it's called your declarations page, sometimes it's 2 or 3 pages worth, you will see the effective, typically it's for a year, sometimes it's for 6 months, the window of coverage that applies to it, and you just have to double check and make sure that's right. Also, if you really want to get into it, somewhere on the declarations pages will be a listing of the forms, and it's all in hieroglyphic code. But it will say, HO, means homeowner, 3, parentheses, 6-99. That means it's an HO3 policy, it's a particular type of policy, and the edition of it was June of 1999. And you can go through each one of those little forms, because those will be listed somewhere on your declaration page. And just check them off as you're going through your policy and make sure you have the right editions, EDITIONs, the right editions of each policy form.
And we're given 2 years to litigate, should we find an inconsistency in what they compensated us for and what the policy actually allows.
It would be 3 years for breach of contract, 2 years for tort of bad faith. In that situation, if they didn't pay you what the contract was, that would be 3.
I have an ACV check that's over $40,000 short, pay off the mortgage, and I disagree with you guys mentioned it took out 5% for contract overhead and it took out 10% depreciation. So should I go ahead and send that check to the bank, or should I continue to negotiate with the insurance company before giving the bank that check?
Sure. Make sure I get this right here. The question is, well, it's kind of a multi-part question, but the insurance company issued a check that for the actual cash value, which oftentimes is what the initial check is for. Actual cash value, but it's $40,000 short of what would be enough to pay off the mortgage. And so his question was to go ahead and send the check to the mortgage company, because they're probably a co-payee on the check, or should he continue to negotiate with the insurance company? I would start by trying to negotiate with the insurance company. However, at some level, at some point in time, your bank will probably grow impatient and is going to want to know what's going to happen with the funds. Mortgage companies can be a challenge to work with, but most of the time, what they really want to see is for you to continue to live up to your bargain in terms of paying mortgage payments, rather than having all the money go to them and you're left with nothing.
Are you considering paying off your mortgage? I wouldn't do it. And the reason is they will stop your ALE. They've been known to say, okay, you paid off your mortgage now, so we know you're not going to rebuild your house because you can't rebuild your house unless you rebuild it out of your savings. So we're going to assume that you're not going to rebuild, and that means your ALE is cut off. And that has happened in Moore, Oklahoma a number of times. You haven't seen it here because we don't know that well. It just is very common. All right, well, yeah, that's a good reason. That's a good reason.
I'm wondering how the insurance companies determine the rates of depreciation on dwellings and contents. And if that's negotiable, and if it's negotiable, how successful could we be?
You do not have to agree with the insurance company's rate of depreciation. You can challenge the rate of depreciation. I'm going to pass the mic to Scott in a second because he'll be able to give you some actual pointers in that regard. But do not let the insurance company tell you, no, there's no room for negotiation here. It absolutely is negotiable. Where do they come up with the numbers? I could bend over and show you.
That's why I love Trump. In reality, nobody knows the condition of your contents better than you do. Nobody. Yet the actual depreciation that should be taken is based on a number of different things. The age, the quality, the condition. The insurance company doesn't know any of that stuff. You're the one that has to tell them, and I believe that it's up to you to tell them how much they should depreciate it, because you need to figure, you know what the useful life is. We had a case, we had a case where water damage, a washing machine hose broke in a basement, flooded the basement. Our client was a model who used to buy her Chanel samples in Paris. She laid out all of these clothes, and the insurance adjuster said, well, how old is that black Chanel dress? And she said, I think it's 20 years old. And the adjuster said, 100% depreciation. That dress has been worn twice. That dress is worth more now than it was when she bought it out of the car. So things don't necessarily depreciate. Sometimes they appreciate. Two questions that I think some guests have, especially those who have total loss. One would be, in order to recover withheld depreciation, do they have to rebuild the house exactly the way it was at that exact location? And two, if you would, please explain to people the difference between being underinsured and not having enough money to completely rebuild their home and being underinsured and not having enough money to qualify for replacement cost of the policy.
What was the first question?
You have to build exactly the same.
Oh, yeah, thank you. That's going to depend on the verbiage of the policy, but the vast majority of today's policies do not require that you build the exact same home. If your foundation is being replaced, you're not required to even build on the exact same footprint. The insurance company would like you to have to rebuild, put back exactly what was there before, but you are not required in most policies to do that. Most policies now also no longer restrict you to having to, in order to get your replacement cost, at having to rebuild on the same site. Most policies also do not require that in order to obtain replacement cost, if you do decide to purchase a new home somewhere else or to rebuild somewhere else, most policies do not require that you have any kind of geographical limitation. I had a client in 4 Mile who decided he wanted to replace, he didn't want to live amongst a bunch of black sticks, so he decided he wanted to go replace in Telluride. The insurance company originally told him, no, you have to rebuild within 60 miles radius. And guess what? There was nothing like that in the policy. And so he came to me and I said, no, you have to do it. And the insurance company paid him to do that, to replace at a different location with no geographic limitation. Again, it's going to be dependent on the verbiage of the policy, but as I said before, if the insurance company tells you you have to rebuild at this place, it has to look the same as it did before, ask them to show you where in the policy it says that. The second question is a considerably more challenging one, which is what will you do if you don't have enough money to replace what you had, and how, I think there was a question there about how does that impact your timelines, or if it didn't, that's certainly a logical implication or extension of the question. If you don't have enough money to rebuild, you may be looking at needing to scale back what you can replace. And again, that's the unfortunate reality of the underinsurance, of the pervasiveness of the underinsurance issue, which is, and I have a client in the Lower North Fork fire who it would take $800,000 to replace his home, and he only had $500,000, including with the extension of $500,000 worth of coverage. So guess what? He's rebuilding a $500,000 home. And he's allowing, and we're in litigation with the insurance company, but he's allowing certain, or the contractor's working with him so that there are certain parts of his home that he can put back together the way it used to be if we end up winning that lawsuit. But it's a really, really tough problem. And again, if you think that you are going to run into problems with respect to the timing of completing your building, and that's questions to start, or discussions to start having with the insurance company sooner rather than later. Now, 60 days more or less out, it's probably a little too early to have it, but as reconstruction is starting to progress along, if you've got you must replace your contents within 1 year, and your house isn't going to be replaced within 1 year, then you want to start having that discussion with the insurance company, I don't know, at the 8-month mark, something like that, because you need to have a place to put all your contents. Nothing will infuriate you more than the insurance company that says, sorry, you have to replace all your contents within 1 year, and your house is barely coming up out of the ground yet. So where are you going to put all this stuff? Well, that's not our problem. Well, just start papering your file early, and again, I would just say about around the 8-month time frame. The insurance company is not obligated to change their policy for you, but so long as you are persistent and are papering your claim, many insurance companies will agree, okay, I guess it's not that critical that you have to replace it within 1 year. You told us that you intend to replace it within 1 year, and they'll cut you some slack sometimes.
I was asking if you could explain to the people the difference between simply not having enough money to rebuild the structure and being underinsured for the replacement cost qualifications of a homeowner's policy.
I'm still not sure that I'm completely following
Scott,
the point.
you got me?
I don't get it, Dave, sorry.
Are you talking about the difference between getting lowballed?
No.
And the difference between being lowballed and being underinsured?
No. One of the problems with being underinsured is that you don't have enough money to rebuild the house.
Yes.
The other problem is if you don't insure to within 8% of the replacement cost value, you're limited to actual cash value you cover.
Okay.
It's actually not home insurance in the home.
Well,
So go ahead.
yeah, okay. They don't call it co-insurance, but that's exactly what it is. And what that means is if you're underinsured by 20% or more, some policies say that the insurance company is only required to pay you actual cash value. That is a gigantic problem, and one that you need to be very careful when you do your valuation so that you can stay within those 8% guidelines and be paid policy limits on a replacement cost basis. That's a really fine line. Yep, I'm seeing them now in homeowner policies. And I'm sure Dave is too. Dave's also a public adjuster. I wanted to add something else. Under one policy that I just looked at,
If you expect to be paid under the extended replacement cost limits, you have to rebuild in the same location. That's an interesting clause that I've never seen before. Have you ever seen that?
I understand.
Yeah, Scott, that's a good point. I have seen that. No, I think it was in a Lower North Fork case where to actually just to access the replacement cost part of your policy, you're not required to rebuild. But if you're going to access some of the extensions, and I don't remember if this was both the code upgrade extension and the extended replacement cost, or whether it was just extended replacement cost, you were required to rebuild at the same location under the verbiage of that policy. Yeah, read your policy.
We have hit 8:15 and we're actually slightly past. Both of our speakers have very generously agreed to just stay here and take questions one-on-one. So if anybody who has a question, they are going to stay here and answer those questions. But I want us to be able to move into our breakout sessions. And I also wanted to acknowledge, my name is Boyd Northhausen from Pikes Peak Long-Term Recovery Group is also here. Boyd, is that you? So again, anybody who wants any information, thank you so much for coming tonight.